you can be, it can be an heir, it can be a son, it can be the surviving spouse, right? Definitely is. In many cases, it could be son, daughter if they're of age, right? If they're not, if they're over the age of 18, and if they're also mature. Just 18 doesn't necessarily mean they're, fit and suitable. In many cases, we learn that they're probably not suitable because they're 18, because they're not mature enough. So an heir, it could be an heir, but doesn't have to be. An executor does not inherit anything from your will. Unless they're also an heir, unless it's your wife or it's your husband or it's your son or a family member who inherits from you. They don't necessarily inherit anything, right? So they just have a very limited function about what they need to do. And then C, again, commonsensical things. Who should it be? Should be someone you trust, someone who understands the Islamic principles and is able to carry them out. And lastly, and many people don't realize this, is that it should be someone local. It should be somebody who is in the area, or at least in the country. A lot of times people ask me, well, can I name my brother, my sister, my father overseas, right? So the question I pose to them, and I answer this question by a question, I ask them, do they have to stand in a line to get a visa to get here? If the answer is yes, that they do, then that's not the right person, right? It should be a person who can immediately act upon whatever needs to be done in case something happens unexpectedly. So it should be. So these are some of the considerations of selecting who the executor is and selecting an executor. The second point is the heirs. Who can be your heirs? And these are, some of the potential heirs. Okay, that can be your Muslim heirs, right? So spouse, children, parents, siblings, and other relatives. Depending on who your surviving family members are, that determines who your heirs are. If your parents are around, then they are part of your heirs. They're considered your heirs. They're, according to Islamic law, they receive something from you. But if they're not around, then it's there's other people who are around. So depending on who the family members are, who the surviving family members are, determines who your heirs is, or making sure, balancing the book, or whatever you want to call it. And recently, and before too, what happens is that if that spouse passes away, everybody else, they have no idea what the assets were, how to get to those assets. So it's important for you to identify them in some way or form, maybe generally. It doesn't have to be many specifically, but generally, okay, for example, 5 bank accounts, or bank accounts at Bank of America and Chase. So some sort of an idea to give the executor a starting point. Because a lot of times people ask me, well, if we identify them so specifically, what if those change, right? So yes, you do have this question about, well, what if these things change? Yes, you do have to then update your documents, but you can be more general and specify those things. That way you're still addressing them, and so the person who is coming afterwards has an idea of where to start from. And then also unidentified assets will go through the Texas law. So what that means is that if you're not identifying assets in your will, and those assets are left out. So for example, let's say you have 2 properties, and you say, okay, this property 1, I want it to go to my Muslim heirs according to Islamic law. Well, you have 2 properties. The second property that you did not identify and mention in the will will not be divided and distributed according to the Islamic law and according to how you want it. It would be distributed according to Texas law, which would be much different than the Islamic law. Okay, so identifying those assets helps achieve those goals. The second point is liabilities. Again, equally important. Is for the same reasons. You want the people to know, well, what are the liabilities? what are the obligations for the family? Well, you don't know, if there is a mortgage or not, or if there are any loans, what needs to be paid so the lights remain on, right? So if you have those things identified, the person, again, who is taking up or who is picking it up after you're gone has some sort of an idea as to where to start from. Okay, and so that's one of the important things that you list is listing liabilities so people know, what you owed and they can be taken care of. After that, you have funeral arrangements. That's another aspect to think about and mention inside your will. A lot of times, there are prepaid expenses, prepaid burial expenses, prepaid, expenses that are associated with funeral and burial. A lot of people prepay them during their lifetime. So if that has happened and you haven't mentioned it, well, guess what? This could have happened like 20 years ago. I have had people for whom I prepared will. They said, well, you know what? Back in the 90s, I think I paid for these expenses. I have to look it up. So if they don't themselves remember what they did 20 years ago, which is, I understand that it's been a long time, how would people who are left afterwards would know unless you've written it down, right? And in this case, what can happen is that you could be paying twice for those expenses. They were paid during lifetime, but you have no record of it, so now you have to pay them again. So again, it's important to have some sort of a record of those for those reasons. Islamic burial rites, Islamically what to do and what not to do, should also be mentioned in an Islamic will. Okay, and then another point that is an important one, and people, especially from our background, they ask me, well, what will happen to myself? What will happen to my body? Will I be taken back? So that has to be addressed, right? And it should be written down in the will that, okay, if something happens to me, then myself should be then buried according to Islamic laws and in the Muslim cemetery, locally, or whatever the case may be. So it has to be written down and addressed. So that's one of the other things that has to be thought about when thinking about preparing your will. So this is probate. Many people may be aware or not aware, and I'll briefly go through what this is because it'll answer some of the questions, or it'll address some of the things in the following slide. Probate is what's called a court procedure to verify the authenticity of the will, of the document that you're leaving behind. So it's a court procedure. So after you have passed away, the surviving spouse or the surviving family have to take the will and submit it for probate to make sure that, okay, the spouse has passed away, the deceased has passed away, who the family members are, and what it said in the will. Whatever it said inside the will, it has to be authenticated by the court. So that's the first step. That's the first reason. And then the second point about probate is that it implements distribution of the will. Whatever it had said, my property goes to A, B, and C. Well, the court then basically approves that distribution, and then it is carried out accordingly. The third thing that it does, the probate, it settles the matters of deceased. So if there were things that needed to be done, if, for example, the banks, a lot of times, if the person has passed away and the property name needs to be, the name of the deceased needs to be removed from the property, the banks usually, and there's a mortgage on the property, then the banks usually will ask for court papers from the probate proceeding in order for them to address those things and remove the name of the deceased. Many times, even banks require, so let's say again, one of the spouses has passed away, the surviving spouse wants to go to a bank and make some changes to the bank account, remove his name, close the account, whatever needs to be done. Since the deceased is named on the account as an account holder, they'll say, okay, well, where are the court probate papers. So, so that's what this does. It's a court proceeding that settles the matters of the deceased, implements the distribution, which is inside the will, and also has the court also is a way of verifying that there's no fraud committed. So can you imagine, my will is being probated while I'm alive, right? So that could be very bad thing because I'm still around and I don't want my property distributed just yet. So it can prevent that. That's the purpose of having that proceeding. Inshallah, we're getting to the FAQs, the Q&A, excuse me, very soon. A couple more slides. A lot of people recently have started asking me, what is a living trust? Specifically, an Islamic living trust. And I will just briefly mention the main components of the Islamic living trust is, and then I'll let you ask questions about it if you have any. So an Islamic or trust, or Islamic trust, in either case, it's a vehicle of basically transferring your assets through to the next generation. So one vehicle we know of is the will. The traditional way that we all know about is having a will written down, and it gets implemented and executed, and there you go. A second way of doing it, a second way of transferring your property to the next generation is through an Islamic trust. So that's what it is. It's just a vehicle of transferring your assets to the next generation. Now it has a lot of other components and aspects, and I'll address a couple of them. So it allows the management of assets during lifetime. So again, that could be a difference too. A will is a document that only takes effect after you've passed away. While you're living, it has no meaning. It doesn't mean anything. Okay, you can change it, you can completely cancel it, and nothing would happen, right? So comparatively, the trust is something that you start and work on during your lifetime. So you can manage the assets during your lifetime, and you can put assets in a trust for specific reasons. This is a trust for charitable causes and reasons, and that's what it's going to do. So there are reasons, there are things that you can do with a trust that you're not able to do with the will because of the functions that they perform. Islamic trust also allows for what's called incremental distribution. A will says, okay, at my death, distribute according to this formula or this scheme, okay, according to Islamic law, the division. The trust allows you to divide the property at someone's passing away according to Islamic law, but distribute at a later time when the kids are of age of majority. So it allows you to not only delay the distribution, but also can help you break it up. So a will, when it says, okay, in a will scenario, you say, okay, my property goes to these people. All of the property, all of the interest. So if it's $1,000 and there's 2 heirs, $500 goes to each person. And immediately when that event happens, the death happens, the property is distributed such that $500 is given to person A, the other $500 is given to person B. Well, in this case, you can actually break it down. You can say 10% of that $500 goes to that person at this event, and then sort of break it down. So 10%, and then 60%, and then whatever percentage that you want. So it is a way of, again, allowing you more management and more control over how you can distribute the assets. And then it's also, as an Islamic will, it also allows you to distribute the assets according to Islamic law. It's in 100% compliance with Islamic law, and it can accommodate all of the rules that are mentioned in the Quran and the Hadith. And another aspect of it is that it avoids probate. So the proceeding that we talked about just the previous slide, and this is the reason why I wanted to talk about it, so this would make sense. When you have a trust prepared, what you do is basically you avoid the court process. You avoid the courts. Okay? So in case of a will, you go to the courts in order to have it implemented and distributed and so on and so forth. With a trust, Islamic trust, you avoid that process. And the reason how you do that is because by the name of it, the property is technically owned by the trust after you've, or even when you're alive. And it's called a living trust. So even after you've passed on, the property is owned by the trust so that there's nothing that needs to go to the court for probate. You have passed on, but technically you didn't own anything. The trust owned your assets. So that allows the family members and the surviving spouse, whoever the family members are, surviving family members, to basically do things privately. Do whatever needs to be done, distribution, payments of expenses, whatever needs to be done, they can do it privately versus having to go to court in case of a will that we talked about. So that's a great advantage, or I guess a benefit of having a trust versus a will. And then, as we said, it says right there, eliminates attorney fees, court costs, and hassle. Because as you imagine, any court proceeding has all these things. You have attorney fees, you have court fees, and you have time consumption. So if you avoid the proceeding itself, and obviously you avoid all those things, the costs and delays. Okay, so with that, I will turn to what I call common questions. And I find this slide to be helpful because it answers a lot of questions that people may have, and these are the questions I've gotten through my career regarding the will. So we will answer these questions and then go to the Q&A session, inshallah. Very first question: is Sharia compliant will valid in Texas? And I will turn to the audience for guesses. What do you think? Do you think is the Sharia compliant will valid in Texas? Yes. What about in Oklahoma? No. Right. No, Sharia compliant will. You don't have to write anything, right? The will that is in compliant with Sharia law, and the answer is yes. It is valid in all states. Okay, if it's valid in the state itself. Okay, if it's a valid will prepared according to the laws of the state. Okay. And now I'm not talking about the substance. I'm not talking about the distribution. The distribution rules don't have to be, but the formalities of having a will prepared. So, quick example. I had a family come to me and they said, "Well, our mothers have passed away. She wrote a will." I said, "Okay." So they came and then they presented the will to me and they said, "Okay, we want things now implemented according to Islamic law." She was, passed on, and her wish was that my property is distributed according to Islamic law to all my children. And I said, fine. So they presented the will to me, and I read everything. Everything was great. Everything was fine. Done. And then I flipped to the last page, and there was no signature. Okay. So she didn't sign it. So because she didn't sign it, it's not a valid will in the state of Texas. So now this Sharia compliant will is not valid in Texas. Not because of the Sharia compliant, because it's not, the legal formalities were not carried out. Okay. So the answer is yes, if the document itself is valid in the state of Texas. This question: upon death, can I give all of my wealth to anyone I wish? What do you think the answer may be? Right. So, exactly. So the question is according to Sharia or according to Texas law? And we can say either. Let's say according to Texas law. Okay. According to Texas law, can you give your property to anyone you wish? Okay. So anybody disagreeing? Here's your chance. So the answer is no, you cannot. There are some state laws that that are in place to secure certain people, okay, namely spouse. Okay, you can't give stuff away unless you have the permission from the Home Office, right? So it doesn't work. It doesn't work like that simply. So if you're married, again, another one of the conditions is you're married in Texas. If that's the case, then you cannot just give away your property to anybody you wish. What about Islamically? All right. Any yeses? No yeses? Okay, good. Yes, the answer is no. All right. That was a trick question because on the first one, it was like all of the it was no, and it was so. Anyways, and then this question, right? So can I disinherit my Muslim heirs according to Texas law first? Yes, no, maybe so. Okay, so it depends. That's the best answer. It depends on who that heir is. Is that a spouse, as I mentioned earlier, or is that a son? So in the case of a spouse, the answer is no, according to Texas law. In the case of a son or a daughter or anybody else, the answer is yes. Okay. Again, the question Islamically is more straightforward, and the answer is: can you disinherit your Muslim heirs? Right. Yes. That's the answer is correct. You may not. Again, and then the question, the following question, and this is the second to last question before I turn it over to the Q&A, is that how long does it take to make a will? And I'll even include the second one, the final question. How much does it cost? It's probably the first thought that entered your mind when you walked in here, that you were thinking about, well, what does it cost? What does it take? And the answer, anybody know? Anybody except for me? Answer is, it depends. Right? So it depends on what it is that you want inside the will, and that determines the time, and it depends. It determines the cost. How complex your situation is. Are there multiple marriages, or there not? Are there kids from multiple marriages, or there not? Are your parents living, or they're not? Do you have property in multiple states, or do you not? So there's no one answer to these questions. It depends. So, but roughly on average, the time it takes, it could take anywhere from 3 weeks to 2 months to have a will and documents prepared. And the cost, again, it varies. It can vary from a few $100s to a couple of $1,000. Depend again on what you want in your will and what your situation is, and that's sort of the answer, the best answer I can give about that. So with that, inshallah, I will turn it over to the next slide, which is Q&A, and I'm happy to, if you could collect, I would appreciate it, if you could collect the cards, and I have the first one with me so I can begin. Just collect the cards and bring them to me, that way I'm able to answer those questions. Walaikum salam. How much time do we have? 10. Sorry? The cards are everywhere. Oh, cards are here. And also, I have this also written down, or this paper, if anybody wants additional information, or like a copy of this presentation, you can write your information on this piece of paper, and then I can get that to you. If you want to, just maybe just pass this or just this sheet around. and then people can just fill out their information and then just check yes or whatever.
If there are any questions from the sisters, they can send the note.
Okay, so do they have a mic or no, they don't? They don't have it.
With piece of paper, we can send them.
Okay. So sisters, if you have questions, would you please somehow get it to us? That's the best I can offer. Thank you. I appreciate it. Thanks a lot. Okay, so yes, of course we would like to answer questions from sister sides as well. Oh, okay. Okay. Jazakallah. Thank you. Thank you. I appreciate it. Okay. So I'm reading the first question, and I want to go ahead and answer that. If I already have, well, can I amend that on my departure? Oh, as it goes gifted only to my spouse and later on served Islamically. So the question is, if I already have a will written down, can I amend that will on my departure, presumably this person is going somewhere, departure amended to say that all assets go to my spouse and then later on distributed Islamically on her departure. Oh, okay, now I get the departure. Okay, on her departure to my children. Got it. Okay. The technical answer is yes, you may amend that. However, the question would be whether that is Islamically correct or not, and that is a question for Islamic, the people who are knowledgeable. But from what I've gathered is you may not give it to one person unless they are of underage. Otherwise, it may not be correct or Islamically correct. The question is, do you need a separate will for each spouse? And the answer is yes. And the reason why is because we live in a state of Texas. By state law, while you're living, the property is divided 50-50 between the spouses. All property that you get after marriage is 50-50, community property state. Okay? So your 50% of the property is distributed according to your will, and your wife's 50% of the property or interest in the property. It could be just one property. It could be one house, right? But that one house, if you got it in Texas after marriage, the default law is that it's 50-50 between you and your spouse. So if you have a will only written for the husband or only written for the wife, that won't transfer the 100% interest that you have in the house. It will only transfer the 50% of the person who wrote the will. So yes, the short answer is yes. Each person has to have their own will. Where do you store the will? In a very safe place. People have safes or another place where it doesn't doesn't catch on fire, or places where it's safe. That's the best advice I can give. Next question is a little too complicated, so I'm going to move to the next one. Where will the liquid assets, and liquid assets here mean cash, be held after death in a living trust? So as we talked about a living trust, so what happens is that during your lifetime, once you create a trust, you create a trust bank account. And all of the assets belonging to the trust are then transferred over to the trust, including the liquid assets, the cash. So that remains inside the living trust bank account. So after someone passes away, the money stays in that account, and then the money gets distributed out of that account. The second question, will the change of a will cost the same as a new one? And the answer is, it depends, but in most cases, no. Does the will need to be witnessed by several people and notarized? Answer is yes. It's two people. It has to be witnessed by two people. And it doesn't have to be notarized. This question is talking about between a will and an Islamic will and Islamic trust. what criteria do you look at to decide which one you select? The criteria is this: if the I would say if the assets, it depends on number of things. If you have assets in multiple states or in even multiple counties, say you have a property in Collin County and a property in Dallas County and so on and so forth, you would be better served with a trust. Because what happens is that after you pass, we talked about probate, right? Probate has to be done in each county where the property is located. So if you reside in Collin County, that's where the probate process will begin, procedure will begin. Then you have to have another probate in Dallas County because you have property there, and then Tarrant County and Hunt County. So if you have property in multiple counties and multiple states, you'll be better served to have a trust. And it's a very loaded question. There's a lot of reasons. There are a lot of reasons why you would pick one or the other, and I can maybe talk to this person one-on-one to go into those details. Okay. Is there a tax exposure to children inheriting wealth? The answer is no. The general rule is that the donor, meaning the person who's giving, always pays the tax. The donee, the recipient, the person who is receiving on the receiving end, never pays tax. Okay. So if you are if you're giving inheritance, the children are on the receiving end. So they don't pay any taxes, but you are the one who pays taxes, whether it's federal tax, state tax, and otherwise. Muslim children inherit non-Muslim parents. Okay, this question, I'm going to try to understand it first. Non-Muslim parents, okay, assets and vice versa. My understanding is that only Muslim heirs inherit from the person who has passed on. Now, technically, you can go into the 1/3 and 2/3 rule, which again I would defer to somebody with the knowledge. But generally, what I know is that you have a discretion to give up to 1/3 to anybody, except for the people who are in the 2/3 category. So what that means basically is that you can give up to 1/3 of your wealth to anybody except for your Muslim heirs. Okay? So, again, technically speaking, the non-Muslim heirs can receive from that 1/3 bucket as a gift, but not as an inheritance. Again, please refer to, this is a very Islamic related question, and I would refer to the Imam here who could check on that for me. This question is, how can we get your service? My information is everywhere posted and my cards are here. Who is responsible for handling court cases? I don't understand this question. An attorney usually is. Again, if you are going through a court proceeding, then an attorney initiates that proceeding. Are there guidelines on who should be designated as a guardian? Answer is yes. Of course, you want the common sense things like someone trustworthy, Muslim, someone who understands your values, someone who would raise your children as if you would want to raise your children. That's going to be the ultimate question, right? Some of the other considerations that people don't think about. Number one, again, as I said, local. If you want to name a brother in India or Pakistan or Saudi or wherever, and if that person has to stand in line to get a visa to get here, then that's not the right person. Because if that person can't come here, and how can they be then the guardian of the minor children? So that's one thing. And number two is that, again, something people overlook. People want to name their parents, especially like elderly parents. So you want to think about, you want someone who has the best interest of the children, who will raise them as you would, but also think about having somebody your age or similar age. right? Because if you name somebody who is, say, your parent, and they pass before you, then you have left that, that spot open. So a couple ways to address that. You can have multiple guardians. You can have 1, 2, 3 guardians in a pecking order. If the first person is around and available, then that person is responsible and becomes the guardian. If that person is not there, in the second and then the third. That's one way. And again, second way is to pick somebody who's closer to your age and hopefully, maybe geographically located close by so they can perform the duties of a guardian. Okay. Next question is a little complicated, aka I don't want to answer in an open forum, so inshallah I'll have this brother maybe ask me this question one-on-one. This is a good question. Do the local courts have jurisdiction over overseas property? And the answer is no. They do not. Can you name a person living overseas as an heir? Absolutely yes. But it'll be their responsibility to get here to actually get whatever's coming to them, right? So, or it will be the responsibility, technically the responsibility of the executor. The executor will be responsible for making sure that whatever share is belonging to that person overseas gets that person. That's part of becoming an executor, that you assume and understand that that's your role and your responsibility, that you make sure that whatever property is divided gets to the named individual. This question is, can you name your minor children as beneficiaries upon reaching the age of 18? I think maybe this is a mistake. Beneficiaries can be, maybe they meant as guardian or executors, because beneficiaries can be named at any time. You can have a newborn as a beneficiary, there's no restriction. But because they mentioned the age 18, I'm thinking that they meant maybe a guardian or a responsible person. And the answer is yes. You can change your guardians or executors when they turn 18. And I've got 2 more questions left, inshallah. Okay, does a living trust override the will? If so, is the living trust sufficient? So, the living trust versus a will, they are, it's one or the other, right? So if you have a trust, you do not need a will. Okay? So because they function the same way, they accomplish the same goal, which is transferring your assets to the next generation. That's the purpose of having either of those. So if you have an Islamic trust set up, then you do not need a will. In fact, it would be counterproductive to have a will and having a trust. Should we put the name of the heirs who live out of the country? The answer is yes, you should. Again, like I said, the person who is responsible, the executor, will be responsible for getting those shares to the named individual who live overseas. This question is, the second question is that what will happen if they can't come to the U.S.? Well, if they can't come to the U.S., then they will not be able to get whatever is coming to them. But again, the executor is responsible for getting that property to them. There are just a couple of questions on this one, and we'll close. Can a Muslim get inheritance from a non-Muslim? I don't see why not. I'll defer this question to the Imam. Can a Muslim get inheritance from a non-Muslim? And I think the answer should be yes. Should be no issues with that. Can a non-Muslim inherit from a Muslim? Again, the consensus is that the answer is no. But again, as I explained earlier, 1/3, 2/3, because a lot of times I get this situation too. You have Muslim brothers who are married to a non-Muslim, people of other faiths. And they ask this question, well, my wife is not Muslim. Does that mean she can't get anything? Well, yes and no. Again, 1/3, 2/3 rule may apply. This is the very last question. The last question, whoever wrote this question, I ask that you contact me. And this again, it's a little complicated. The answer is a little complicated. And if I may talk to you one-on-one, I would love to do that and answer your questions, inshallah. So inshallah, with that, we will close. I appreciate your attention, your time, and your questions. If you have any other questions, again, after the fact, I'll be around for a few minutes, and then, of course, you have my contact information. Jazakumullah khair. Assalamu alaikum.